The courthouse doors opened at exactly 8:47 a.m., and Margaret Chen walked through them, carrying a leather briefcase that weighed less than 5 pounds, but held the power to destroy an entire resort community. For 6 months, the Pleasant Valley HOA had treated the 62-year-old agricultural law attorney like she was nothing more than an obstacle to their luxury development dreams. They'd ignored her credentials, dismissed her warnings, and yesterday they'd actually sold 2,400 acres of her family's century-old farm without her permission. But this morning, in Judge Patricia Morrison's courtroom, Margaret was about to teach them the most expensive lesson of their lives. Before we see how a retired attorney dismantled an entire HOA in less than 24 hours, if you love stories where entitled people learn that credentials matter and arrogance has consequences, hit that like button and subscribe. Now, let's see exactly how this unfolded. This is a story in 3 parts. The violation that pushed a legal expert too far, the confrontation where decades of experience met amateur hour corruption, and the resolution where an entire resort community learned. Why you never underestimate a property law specialist, Margaret. Chen had spent 35 years practicing agricultural and property law before retiring to the 2,400-acre farm her grandparents had established in 1924. She'd warned the Pleasant Valley HOA, a luxury resort community built adjacent to her land, that their aggressive expansion plans violated multiple easements and property rights. She'd offered to negotiate. She'd provided legal documentation. She'd been patient, professional, and clear. But the HOA board, led by real estate developer Brandon Walsh, saw only an elderly woman they could intimidate into selling. They saw an opportunity to triple their property values. What they didn't see was the strategic mind that had won landmark cases against corporations 10 times their size. The confrontation would happen faster than anyone expected. Within 18 hours of the fraudulent sale, Margaret would be standing before a judge with documentation so devastating that the HOA's attorney would literally ask for a recess to advise his clients to settle. And the resolution would cost the Pleasant Valley HOA everything they'd built, literally. Here's exactly how it happened. Margaret Chen had practiced property law in 3 states before retiring at 60 to the farm that had been in her family for 101 years. She wasn't the kind of retiree who played golf or took cruises. She spent her mornings working the land her grandfather had cleared by hand, her afternoons reading case law in the study where her father had taught her to love the legal precision of property rights, and her evenings preparing lectures for the agricultural law course she still taught online at UC Davis. The 2,400 acres weren't just land to Margaret. They were legacy, history, and the culmination of 4 generations of careful stewardship. She'd turned down 7-figure offers from developers over the years. The farm wasn't for sale. It would never be for sale. The Pleasant Valley Resort community had been built 5 years ago on the adjacent property, a gated development of 200 luxury homes surrounding an 18-hole golf course, spa facility and clubhouse that looked like it belonged in the Hamptons. The HOA fees alone were $1,200 monthly. The board president, Brandon Walsh, was a 43-year-old commercial real estate developer who'd made his fortune flipping properties in the Bay Area. He saw Margaret's farm the way a shark sees blood in the water, as opportunity. The resort's property values would triple if they could incorporate her land, extend the golf course, add luxury cabins along her creek. Walsh had approached Margaret 6 months ago with an offer of $15 million for the entire property. Margaret had declined politely, explained the farm wasn't for sale, and thought that would be the end of it. She was wrong. 3 months later, the HOA sent her a letter claiming her farm violated their community covenants that predated her family's ownership by 80 years, which was legally impossible. Margaret responded with a detailed legal memo explaining why their claim had no merit, including citations to relevant case law and a timeline of property ownership. Walsh responded by hiring an attorney who sent increasingly aggressive letters threatening legal action if Margaret didn't comply with their community standards. She replied to each letter methodically, documenting every false claim, every legal error, every attempt at intimidation. Then, 2 months ago, things escalated. The HOA filed a lien against her property for unpaid community fees, fees she'd never owed because her farm predated their community and wasn't part of their covenant. Margaret attended the HOA meeting to dispute the lien in person. Walsh had smiled at her from the head table like she was a confused grandmother. "Mrs. Chen," he'd said, his voice dripping with condescension, "we understand property law can be confusing for someone your age. Perhaps it's time to let professionals handle this." Margaret had calmly introduced herself as a retired attorney who'd practiced property law for 35 years, specializing in agricultural land disputes. Walsh's smile had faltered, but only briefly. "Then you should understand that we have every right to enforce our community standards." The board had voted unanimously to maintain the lien. Margaret had filed a motion to dissolve the fraudulent lien. She'd won. The judge had specifically noted in his ruling that the HOA's claim was without merit and appeared to constitute harassment. Margaret had assumed that would be the end of it, that the HOA would back down, that Walsh would realize he'd picked a fight with someone who actually knew the law. She was wrong again. Yesterday morning, Margaret had received notification that the Pleasant Valley HOA had sold her entire 2,400-acre farm to a development corporation for $32 million. They'd forged her signature on transfer documents, filed them with the county recorder, and deposited the money into an HOA account. Walsh had called her personally to inform her she had 30 days to vacate. "You should have taken our original offer," he'd said. "Now you get nothing." Margaret had hung up the phone, opened her laptop, and spent the next 6 hours preparing a legal filing that would change everything. By midnight, she'd submitted an emergency motion to Judge Patricia Morrison. By 3 a.m., she'd received confirmation, hearing scheduled for 9 a.m. By dawn, Margaret was already dressed and heading to the courthouse, her briefcase containing not just the documentation to void the fraudulent sale, but something the HOA had never expected, something that would cost them everything. Judge Patricia Morrison's courtroom filled quickly. Margaret sat at the plaintiff's table alone, her briefcase closed, her expression calm. Across the aisle, Brandon Walsh sat with 3 other HOA board members and their attorney, Marcus Pemberton, a mid-level real estate lawyer who'd probably handled hundreds of property transfers but never dealt with someone like Margaret. They were laughing quietly among themselves, confident. Walsh kept checking his watch like this was an inconvenience rather than the end of his world. Judge Morrison entered at 9:03 a.m. She was 58, a former prosecutor who'd made her reputation dismantling white-collar fraud cases. She'd read Margaret's emergency filing. She didn't look pleased. "Ms. Chen," she began, "you've filed a rather extraordinary motion. Multiple counts of fraud, forgery, conspiracy to commit grand theft. These are serious allegations against an HOA board." Margaret stood. "Your Honor, I have documentation for every charge. The defendants sold 2,400 acres of property they don't own, forged my signature on transfer documents, and deposited $32 million into their accounts. I'm not alleging fraud. I'm proving it." She opened her briefcase and pulled out the first folder. "Exhibit A, the deed to my property, registered in 1924 under Chen family ownership, continuously held for 101 years. Exhibit B, the fraudulent transfer documents filed yesterday containing a forged signature that any handwriting expert can verify isn't mine. I was in Sacramento yesterday teaching a class with 47 witnesses. Exhibit C, bank records showing the $32 million deposit into Pleasant Valley HOA accounts, split among board members in a way that suggests premeditated distribution of stolen funds." Walsh's attorney stood quickly. "Your Honor, this is a misunderstanding. The HOA believed—" "There is no misunderstanding," Margaret interrupted, her voice sharp enough to cut glass. "There is fraud. And I'm not finished." She pulled out another folder, this one significantly thicker. Exhibit D, the original property survey of Pleasant Valley Resort Community from 2019. Your Honor, I'd like the court to note something interesting about this survey." She approached the bench and laid out a large map. Judge Morrison leaned forward, studying it. Walsh's smile was finally gone. "The Pleasant Valley Resort," Margaret continued, her voice steady and cold, "was built on 480 acres. The golf course, clubhouse, spa facility, and all 200 homes sit on those 480 acres. However, the original developer who sold this land to Mr. Walsh's investment group 5 years ago made a rather significant error. They sold him property that included a 60-acre section that was never actually owned by the seller. That 60-acre section contains the resort's main clubhouse, the spa facility, and the first 6 holes of their golf course. That 60-acre section has been part of my family's property since 1924, incorrectly surveyed in 2019, and never legally transferred. The courtroom went silent. Walsh had gone pale. His attorney was frantically flipping through documents. "I discovered this survey error 3 months ago," Margaret said, returning to her table. I attempted to resolve it quietly. I offered to sell the HOA that 60-acre parcel for fair market value, approximately $2 million. Mr. Walsh responded by trying to steal my entire farm. So now I'm exercising my rights as the legal owner of that 60-acre section. I'm demanding immediate possession of my property, which means the Pleasant Valley HOA has built their primary facilities on land they don't own and never owned. Judge Morrison looked at Walsh. "Mr. Walsh, does your attorney need time to verify these claims?" Pemberton stood slowly. His face had gone from confident to ashen. "Your Honor, I need to consult with my clients immediately." "If Ms. Chen's survey documentation is accurate, it is," Margaret said simply. She placed one more document on the table. "This is the original 1924 survey, the 1956 resurvey, and the 1983 boundary verification. All 3 confirm the same property lines. The 2019 survey that Pleasant Valley relied on was conducted by a firm that has since been investigated for fraud in property assessments. I have testimony from the surveyor who admitted to cutting corners. The 60 acres containing your clubhouse, spa, and 6 golf holes belong to me." "They always have," Walsh finally spoke, his voice hoarse. "You can't do this. We have 200 homeowners who paid. You should have thought about that before you forged my signature and tried to steal my family's farm," Margaret said coldly. "You wanted to play property games with a property attorney. Congratulations. You just lost." Judge Morrison called a 30-minute recess. Margaret watched Walsh and his board members huddle with their attorney in the hallway. Through the glass, she could see Pemberton's animated gestures, Walsh's face getting redder. She opened her laptop and reviewed her settlement terms one more time. She'd practiced law long enough to know how this would end. 20 minutes later, Pemberton requested to approach the bench with a settlement proposal. The settlement conference lasted 90 minutes in Judge Morrison's chambers. Margaret sat across from 5 men who'd spent 6 months trying to intimidate her into selling her land, and now sat facing bankruptcy, criminal charges, and the destruction of everything they'd built. She listened to Pemberton's opening offer: void the fraudulent sale, return the farm to Margaret, pay $500,000 in damages, and resign from the HOA board. Margaret had smiled, the same smile her opposing counsel had learned to fear over 3 decades in courtrooms. "No," she'd said simply. Then she'd laid out her terms. First, the fraudulent farm sale would be voided immediately. All documents destroyed, all records corrected, the $32 million return to the Development Corporation with interest. Brandon Walsh, along with board members Kevin Torres, Patricia Henderson, and Michael Drummond, would be removed from the HOA board permanently and banned from holding any HOA position in California. Each would face civil penalties of $250,000 for their participation in the fraud. The HOA would issue a public apology to Margaret, posted in every community newsletter and on their website for 1 year. Second, the 60-acre survey error. Margaret owned that land. The clubhouse, spa facility, and 6 golf holes sat on her property. The HOA had 3 options. Purchase the land from Margaret for $8 million, 4 times the original offer she'd made in good faith 3 months ago. Lease the land from Margaret at $400,000 annually with a 30-year term. Or tear down their facilities and return her land to its original state within 90 days. Walsh had exploded at option 2. $8 million? You offered us $2 million 3 months ago. This is extortion. Margaret had looked at him with the same cold expression that had once made a Fortune 500 CEO weep during a deposition. 3 months ago, I offered to help you fix your survey error quietly. You responded by trying to steal my farm. You forged my signature. You committed fraud. You told me I should have taken your original offer and that I'd get nothing. Mr. Walsh, I'm a property attorney. I know exactly what my land is worth, and more importantly, I know exactly what your resort is worth without access to that land. Your clubhouse serves 200 homes. Your spa generates $2 million annually. Your golf course is rated top 10 in the state. Without those 6 holes, your course is worthless. Without your clubhouse, your HOA has no meeting space, no administrative offices, no community center. Without your spa, you lose your main attraction. So yes, $8 million. And that's generous considering I could demand you tear it all down and file for the cost of land restoration, which would exceed $15 million. The room had gone silent. Judge Morrison had reviewed Margaret's documentation, verified her ownership claims, and confirmed the legal standing of her demands. Walsh's attorney had requested a private consultation with his clients. 15 minutes later, they'd returned with acceptance of Margaret's terms. The HOA would purchase the 60 acres for $8 million paid in full within 60 days. All board members would resign. Criminal charges would be referred to the district attorney for prosecution. The fraudulent sale would be voided immediately. 2 months later, Margaret stood in her farmhouse kitchen, morning sunlight streaming through windows that overlooked 2,400 acres of land that had remained in her family's hands. The Pleasant Valley HOA had dissolved entirely. The $8 million had been paid in full. Walsh faced 3 counts of fraud and forgery, his real estate license suspended, his reputation destroyed. The other board members had settled their civil penalties and quietly moved away. The resort community, now under new management, had voted to establish a community trust fund for Margaret's agricultural education program of $50,000, annual contribution to fund scholarships for students studying agricultural law. Margaret's phone rang. It was her former colleague from UC Davis asking if she'd consider teaching an additional course next semester on property rights and HOA law. She'd agreed immediately, because if 6 months of dealing with Brandon Walsh had taught her anything, it was that the next generation of property attorneys needed to know that credentials matter, that experience counts, and that trying to intimidate someone who's spent 35 years mastering the law will cost you everything you have. She walked outside to her porch, coffee in hand, and looked across land her grandfather had cleared by hand in 1924, land her father had defended against developers in the 1970s, land she'd just defended against the most aggressive HOA board she'd ever encountered. The farm wasn't for sale. It would never be for sale. And now finally everyone knew it. Margaret had learned long ago that justice doesn't always come from a courtroom. Sometimes it comes from knowing the law better than anyone else in the room. And as she sat there in the morning quiet, watching the sun rise over property that would remain in her family for another century, she smiled. Because justice, served hot or cold, was equally satisfying, especially when it cost the other side $8 million and their freedom. Across the country in Portland, Oregon, retired Marine Corps logistics officer Daniel Park was reviewing his property tax statement when his condo HOA demanded he remove the memorial flag display honoring his fallen unit members. The 55-year-old veteran smiled, the same smile that once preceded procurement negotiations with generals, and pulled out the federal freedom to display the American Flag Act of 2005, which he'd helped draft testimony for during his Pentagon assignment. "Please," he said quietly, "keep making demands about federal law. I'd love to see how that works out for you." The HOA president went silent. "But that's a story for another time,"